This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a very unusual circumstance when an MRI machine explodes, only to find that there's no coverage since the injuries were not related to the use of the MRI, and the policy was specific to that use. In John Fitzpatrick and Colleen Fitzpatrick versus Oradell Animal Hospital, Inc., a November 1, 2022 decision of the Superior Court of New Jersey Appellate Division, plaintiffs John Fitzpatrick and Colleen Fitzpatrick appealed from a June 17, 2021 order granting summary judgment in favor of defendant Continental Casualty Company. Plaintiffs sustained injuries on March 6, 2015 when a magnetic resonance imaging, or MRI machine, installed at defendant Oradell Animal Hospital exploded. Oradell leased the MRI machine from defendant Advanced Veterinary Technologies on December 17. Oradell and AVT signed an agreement to lease the MRI machine with a 5-year renewal option beginning on April 1 of 2004. The lease agreement required AVT to install the MRI machine at Oradell's facility. At the end of the term, the lease agreement provided AVT shall deinstall, inspect, test, pack, remove, and ship the MRI machine at AVT's expense. The lease agreement also stated AVT was responsible for the repair of any damage to Oradell's premises on account of the removal of the MRI machine. Additionally, the lease agreement required Oradell to maintain insurance for loss, theft, or damage to the MRI machine in the amount of $550,000, naming AVT as an additional insured and loss payee. Oradell complied with this provision by purchasing insurance from Continental. Continental issued a commercial insurance policy to Oradell covering the period September 21, 2014 to 2015. Under the coverages section of the policy, Continental agreed to pay those sums that Oradell becomes legally obligated to pay as damages because of bodily injury, property damage, or personal and advertising injury to which the insurance applies. While decommissioning the MRI machine, Hogan testified he picked something up off the ground and was surrounded by a white cloud of helium. A split second later, the MRI machine exploded, and the next thing Hogan remembered was waking up on the ground. Plaintiff and Hogan suffered injuries from the explosion. On August 31, 2017, plaintiffs filed a third amended complaint against Oradell, Halpern, AVT, Hogan, and others. On February 22, 2018, Hogan filed a cross-complaint against Continental seeking insurance coverage under the policy. After completing discovery, including depositions, Hogan moved for summary judgment, asserting Continental had an obligation to provide him with insurance coverage for plaintiff's claims. The plaintiffs joined in Hogan's motion. The motion judge heard oral argument on November 9, 2018, and in an 8-page written decision, the judge found Hogan's actions did not arise out of Oradell's maintenance, operation, or use of the MRI machine, which was a condition of the policy, and because Hogan was decommissioning the MRI machine on the date of the explosion. Additionally, the judge found no substantial nexus between the plaintiff's injuries, Hogan's conduct, and any negligent maintenance, operation, or use of the MRI machine by Oradell. To the contrary, the judge concluded that decommissioning of the MRI machine was the antithesis of the maintenance, operation, and or use of the MRI. After a proof hearing, the judge entered a June 14, 2021 judgment in favor of plaintiffs and against AVT, awarding damages in the amount of $1,383,555.67 to John Fitzgerald and $115,296.31 to Colleen Fitzpatrick. The court concluded that there was no ambiguity regarding the phrase written contract or agreement as used in the policy. The fact that litigants offer conflicting interpretations of policy language does not render the policy language ambiguous. A genuine ambiguity arises only when the phrasing of the policy is so confusing that an average policyholder cannot make out the boundaries of coverage. Moreover, equipment is only decommissioned upon the expiration of the lease term. As stated in the lease agreement, at the scheduled conclusion of the lease, AVT shall deinstall, remove, and ship the MRI machine. Under the express terms of the lease agreement, the lease must terminate before decommissioning begins. For Hogan to be eligible for coverage under the policy, there had to be a substantial nexus between the plaintiff's injuries and Oradell's maintenance, operation, or use of the MRI machine. The uncontroverted evidence demonstrated no Oradell employee was in the room when the MRI machine exploded, nor had any Oradell employees participated in the 2-day decommissioning process prior to the explosion. On that record, there was just no evidence Oradell maintained, operated, or used the MRI machine after March 4, 2015. Thus, the judge properly granted summary judgment to Continental. In my opinion, always interesting and heartening to see a court opinion where the court read every word of the insurance policy, noted that for coverage to apply, the entity seeking insurance must first maintain, operate, or use the machine at the time it exploded and caused injury, and since they were nowhere near the machine, had nothing to do with it being decommissioned, they were not insured at the time of the explosion, since it was in the control of the lessor, who was working to decommission the MRI, and without the lease being in effect at the time of the explosion, the insurance provided no coverage. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the link zelma.com/blog. You should subscribe if you find these blog postings to be interesting or useful to you, and you might also wish to subscribe to the Rumble videos and or the YouTube videos. And if you do and watch this video on YouTube or on Rumble, please click on the like button on YouTube and the Rumble button on Rumble. Please also tell your friends and colleagues about these blogs and these blog postings and the videos so that they too can subscribe. Thank you for your attention.